Breaking today, the Supreme Court just delivered a 6-3 decision that could fundamentally reshape the future of so-called assault weapon bans across the United States. And if you are seeing headlines fly across social media right now, slow down for a second, because what just happened is big. Not symbolic big, not incremental big, potentially structural, constitutional, permanent big, but like always, the details matter, and the way this decision connects to the Department of Justice's latest move may be even more important than the vote count itself. So here's the simple question on the table today. Did the Supreme Court just open the door to permanently ending assault weapon bans nationwide? That is what many are claiming. That is what others are denying. And as usual, the truth sits entirely in the legal reasoning. Now, before we go deeper, if you appreciate clear, honest breakdowns of complicated constitutional issues like this, make sure you are subscribed. These cases move fast. The headlines move even faster. And what matters most is understanding what the court actually said, not what activists on either side wish it said. In a 6-3 ruling, the Supreme Court reaffirmed and significantly strengthened the framework first laid out in New York State Rifle and Pistol Association versus Bruen. That case established that when evaluating gun regulations, courts must look to the text of the Second Amendment and the historical tradition of firearm regulation at the time of the founding and nothing else. No more modern interest balancing, no more judicial weighing of government safety interests against constitutional rights. In today's decision, the court made it unmistakably clear that lower courts cannot sidestep that standard by rebranding old balancing tests in new historical language. That matters enormously. For years, lower courts, particularly in the Ninth and Fourth Circuits, have upheld assault weapon bans by arguing that certain rifles are military style or unusually dangerous. The Supreme Court today did not directly strike down every pending rifle ban case by name. But what it did was close the escape hatch that those lower courts have been using, and that is in many ways more consequential than a single targeted ruling. The majority opinion emphasized that firearms commonly possessed by law-abiding citizens for lawful purposes fall squarely under the protection of the Second Amendment. And here is where things become critical. The court reiterated language from District of Columbia versus Heller, specifically that arms in common use by the American public are protected. Now think about that phrase, common use. AR-15 style rifles are owned by an estimated 24 to 30 million Americans. They are among the most popular rifles in the entire country. They are used for home defense, recreational shooting, competition, and hunting across dozens of states. Lower courts have tried to carve them out of constitutional protection by labeling them weapons of war or unusually dangerous military instruments. But the Supreme Court today signaled very clearly that widespread, lawful ownership matters far more than aesthetic features or political labels assigned by legislators or judges. For a long time, the liberal wing of the court and certain hesitant justices were reluctant to touch the assault weapon question directly. They leaned on arguments about dangerousness and evolving technology, but the 6-3 alignment we are seeing now signals something fundamentally different. This is not a fragile one-vote majority. This is a stable, durable constitutional supermajority that has grown increasingly impatient with lower courts that openly ignore or creatively circumvent Supreme Court precedent. Justice Thomas has recently noted that the AR-15 is the most popular rifle in America. When 24 to 30 million Americans own a specific type of firearm for lawful purposes, it is, by definition, in common use. That is not a political opinion. That is a simple mathematical and legal reality under the framework the court itself established in Heller. And a 6-3 split projects the kind of long-term stability that changes how every actor in this legal landscape behaves. State attorneys general become less willing to pour resources into defending bans they suspect will eventually fall. Lower court judges get ahead of the issue rather than waiting to be corrected. And legal challenges move faster toward a final resolution. The majority in today's decision also emphasized something that will echo through litigation for years. Constitutional rights do not shrink simply because technology advances. That one line closes the door on one of the most common arguments used to justify modern bans, which is the idea that today's firearms are simply too advanced to receive full constitutional protection. The founders could not have anticipated them, the argument goes. The court has now responded to that argument clearly and firmly, and that brings us to the second massive development happening simultaneously. While this 6-3 decision was released, the Department of Justice filed new arguments in ongoing litigation challenging state-level assault weapon bans. The DOJ's position is that categorical bans on entire classes of commonly owned firearms are constitutionally suspect under the framework reaffirmed today. Pause on that. For the past several years, the Department of Justice was the primary legal defender of gun regulations at the federal level. It filed briefs defending bans, supported ATF regulatory overreach, and provided the institutional backbone that gave anti-gun states credibility in federal courts. That era is now over. With the establishment of a new Second Amendment section within the Civil Rights Division, the DOJ has flipped the script entirely. They are now filing briefs and launching their own legal challenges, including against the District of Columbia, arguing that assault weapon bans are a violation of civil rights. Think about how significant that is. You now have the federal government's own lawyers standing up in court and saying these bans are unconstitutional. This is not a think tank position. This is not a legal theory floated in a law review article. This is the official position of the United States government. That changes the strategic landscape for every state defending an assault weapon ban. State attorneys general can no longer rely on federal legal authority to bolster their arguments in court. The federal government is not just standing aside. It is actively working against them, and by moving these cases into the Civil Rights Division and invoking pattern or practice authorities, the DOJ is categorizing the right to bear arms as a fundamental civil right on par with voting and free speech. We have seen patent or practice investigations used against police departments for civil rights violations. The DOJ is now turning that same legal authority against the cities and states themselves, alleging that jurisdictions like Washington, D.C. and Los Angeles are engaged in a systematic practice of depriving citizens of their constitutional rights. That framing is not accidental. It is strategic. It is designed to create a uniform federal question that stretches across multiple circuits simultaneously, laying the groundwork for what could ultimately become a single definitive national ruling that resolves this question everywhere at once. Now let us look at the specific legal battlefield, because the pressure points are real and they are building fast. Two cases are currently at the tip of this legal spear: Bianchi versus Brown out of Maryland and Duncan versus Bonta out of California. These are the cases most likely to become the final vehicles for this story, and both are now under enormous constitutional pressure from today's strengthened framework. In the Bianchi case, the Fourth Circuit issued an en banc ruling claiming, remarkably, that the AR-15 is not even an arm protected by the Second Amendment because it is too similar to an M16. That ruling was widely criticized as a desperate attempt to manufacture a legal loophole to avoid the Bruen mandate. Today's Supreme Court decision makes that kind of reasoning far more difficult to sustain. When the court says the historical test must be applied faithfully and cannot be disguised with new language, it is directly addressing the kind of creative workaround the Fourth Circuit attempted. In the Duncan case out of California, Judge Benitez has repeatedly ruled that California's magazine ban is unconstitutional, only to be reversed by a Ninth Circuit panel that refused to fully apply Bruen's framework. That cycle of lower court resistance is exactly what the Supreme Court appears to be targeting with today's stronger language. The DOJ has filed statements of interest in magazine cases as well, arguing that arbitrary round limits constitute an infringement on protected arms. And here is why magazines matter so much. You cannot have a functioning AR-15 without a standard capacity magazine. If the court rules that commonly owned magazines are integral components of protected arms, the magazine bans in more than a dozen states collapse alongside the rifle bans. Justice Alito recently noted that some lower courts are treating the Second Amendment as a second-class right. The new DOJ Second Amendment section is the institutional response to that concern, filing statements of interest in pending cases to remind federal judges that they cannot ignore Supreme Court precedent simply because they disagree with the outcome. So what comes next? What are the realistic paths forward from this moment? One path is that the Supreme Court grants certiorari in one of these pending cases, schedules oral arguments, and issues a definitive ruling this term or next. That would put us on a direct timeline for the clearest Second Amendment ruling since Heller itself. Another path is a GVR, meaning grant, vacate, and remand, where the court sends pending assault weapon cases back to lower courts with explicit instructions to reconsider them under today's strengthened standard. That approach allows the court to apply pressure without immediately writing a sweeping national headline opinion. But there is real risk in the incremental approach, and the court knows it. Some lower courts have already demonstrated a willingness to resist Bruen's framework, relabeling interest balancing as historical analysis and reaching the same pro-regulation conclusions they always have. If that pattern continues after today's stronger signal, the Supreme Court will likely conclude that suggestion is not enough and that direct binding clarity is necessary. With the DOJ now actively aligned with the plaintiffs in these cases, the court's usual concern about whether the government's interests are being fairly represented has been eliminated. The federal government is now on record telling the Supreme Court that its own data shows these rifles are overwhelmingly chosen by Americans for lawful purposes. Lower courts cannot claim a firearm is unusual when the federal government is officially testifying to the contrary in the very cases before them. Now let us talk about what a definitive ruling would actually mean in practice, because this is where constitutional theory becomes real-world consequence for millions of people. A Supreme Court ruling that commonly owned semi-automatic rifles cannot be categorically banned would immediately threaten state bans in California, New York, Maryland, New Jersey, Illinois, Connecticut, and others. Ongoing enforcement would likely be halted through emergency injunctions. Pending prosecutions based solely on possession of banned firearms could be dismissed or re-examined. State legislatures would be forced to fundamentally reassess their regulatory frameworks from the ground up. Critically, it would not stop at the state level. If the court establishes that AR-15 style rifles are protected arms, any future federal assault weapon ban would face the same constitutional challenge and almost certainly fail under the same reasoning. The constitutional boundary, once drawn clearly, applies to Congress just as it applies to the states. The policy debate does not disappear, but it shifts from whether to ban to how to regulate within constitutional limits. That is a fundamentally different legal world. We should also be precise about what such a ruling would not do, because misconceptions on this point create confusion that muddies the broader debate. A ruling that categorical assault weapon bans are unconstitutional would not eliminate all gun regulation in America. Background checks remain, federal licensing requirements remain, age restrictions remain, regulations on the manner of carrying firearms remain, subject to their own analysis under Bruen. What ends is the specific practice of banning a firearm outright simply because it has certain physical features, when that firearm is already lawfully owned by tens of millions of Americans. The constitutional line is not between regulation and no regulation. It is between permissible regulation and categorical prohibition of commonly owned arms. Now we need to address the argument that keeps coming up from those defending these bans because it deserves a serious response. The argument is this: even if AR-15s are in common use, the government has a compelling interest in restricting them because of the scale of harm they enable. It is an emotionally powerful argument, but under the current legal framework, it is constitutionally insufficient. The Bruen test does not ask whether the government has a good reason for its regulation. It asks whether the regulation is consistent with the historical tradition of firearm regulation in America at the time of the founding. The historical record does not contain categorical bans on commonly owned firearms. The founders regulated the manner and circumstances of carrying arms. They did not prohibit entire classes of widely owned weapons. That is the distinction upon which these modern bans are legally collapsing. The three dissenting justices made the evolving technology argument clearly and with genuine force. They argued that the founders could not have anticipated the destructive capacity of modern semi-automatic firearms in the wrong hands. It is a serious argument made by serious legal minds. The majority rejected it on a foundational principle. Constitutional rights do not diminish as the technology they protect evolves. The First Amendment protects speech on the Internet even though the founders had no concept of it. The Fourth Amendment protects against digital searches even though nothing like that existed in 1791. The Second Amendment must be treated with the same intellectual consistency, and today's majority applied exactly that. There is one more dimension that deserves direct acknowledgement: the practical reality for millions of ordinary Americans who have been living under these restrictions for years, in some cases for decades. In states like California, Illinois, Connecticut, Maryland, and New York, owning a rifle with certain physical features is a criminal offense. People have been prosecuted, businesses have been shut down, law-abiding citizens have been treated as criminals for owning one of the most popular rifles in the country. Whatever one thinks about the policy debate, those are real consequences for real people exercising what the court itself says is a constitutionally protected right. When the Supreme Court issues its final ruling on this question, those consequences end through a constitutional holding that no future election can reverse. That is the full weight of what is potentially approaching. Today's 6-3 decision, combined with the DOJ's unprecedented reversal, represents a convergence of forces unlike anything we have seen in Second Amendment litigation. The doctrine is tightening, the majority is stable, the federal government has changed sides. The lower court escape hatches are being closed one by one. The specific cases that are best suited to be the final legal vehicle are already in the pipeline. Whether the final chapter is written this term or next, the direction of travel has never been clearer. Let us also consider the strategic question of which case ultimately becomes the vehicle the court chooses to write the final answer. Does the court take Bianchi out of Maryland, where the Fourth Circuit's reasoning was arguably the most aggressively wrong? Does it take Duncan out of California, where the cycle of lower court resistance to Bruen has been playing out the longest and most publicly? Or does the court consolidate multiple cases into a single massive proceeding that addresses rifles, magazines, and other challenged features simultaneously? Each path carries different implications for the scope and finality of the ruling. A consolidated approach would be more sweeping, but more complex to craft. A single well-chosen case would be cleaner and faster to resolve, but might leave residual questions requiring follow-up litigation in subsequent terms. The court's recent pattern of relisting these petitions repeatedly suggests that justices are actively debating precisely this question, working through which vehicle gives them the cleanest record and the most complete factual foundation to write a durable opinion that cannot be easily distinguished or worked around by lower courts in the years ahead. There is also the question of timeline and what the end of this Supreme Court term means practically. The court typically issues its most significant rulings in late June. If certiorari is granted in one of these cases before the end of this month, oral arguments would likely be scheduled for the fall term, putting a final ruling on track for June of next year at the latest. If instead the court issues GVR orders this term and waits to see how lower courts respond, the definitive ruling could come a full term later. Gun rights litigants and advocates have been waiting through multiple rounds of this cycle for years now, but the combination of factors present today, the strength in doctrine, the DOJ reversal, the specific cases in the pipeline, and the 6-3 majority makes the next 12 months the most consequential window this movement has seen since Heller was decided in 2008. One final point is worth making as we close out today's analysis, and that concerns the broader significance of what is unfolding beyond just the gun rights community. The Second Amendment debate in America has long been treated as a niche legal and political issue, important to its advocates but peripheral to the mainstream constitutional conversation. What is happening right now is something different. The Supreme Court is in the process of firmly establishing that the Second Amendment is a first-class constitutional right, subject to the same rigorous protection as the First Amendment or the Fourth Amendment, not a discretionary policy preference that courts can trim or expand based on contemporary political winds. That principle, once cemented in a clear definitive ruling, has implications that extend well beyond the specific question of any one rifle or magazine. It establishes the methodology by which the court evaluates the entire landscape of American gun regulation going forward, and that is why legal scholars, policy experts, and constitutional attorneys across the political spectrum are watching these cases with the kind of attention typically reserved for only the most foundational moments in American legal history. If you want to stay ahead of every order list, every conference decision, and every new filing in these cases, subscribe now. The next few months could bring developments that reshape the constitutional landscape for generations. When that order list drops on Monday morning, we will be right here breaking it down for you in plain language, without spin, without noise, just the legal reality of what it means for your rights. Because that is what this moment demands, and that is what we are here for.